Well, hello, everybody, and welcome to this new edition of Tomaskycast. I'm Michael Tomasky. I'm the editor of the New Republic. Tomaskycast is a product of TNR Video, and we have a terrific guest today. That's Michael Waldman. Michael is the director, president, CEO. What are you, Michael?
President and CEO.
President and CEO of the Brennan Center for Law and Justice out of the NYU Law School. It's a great organization that works so hard on so many important fronts: voting rights, gerrymandering, so many different things. And Michael, you've been the head of the Brennan Center for how long?
17 years.
17 years, and he's really turned it into a powerhouse. Well, we'll talk about that a little bit, but we're actually here to talk about his new book. He cranks out books like crazy too, and this is the book. This is the galley. It's not the book, but that's what the cover will look like. And it's called The Supermajority: The Year the Supreme Court Divided America. And it's just out this month. From who? Who's the publisher?
Simon and Schuster.
Simon and Schuster. So, Michael, welcome.
It's great to be with you. And the New Republic, as it covers the court, but so much else right now, is on fire. It's just a vital force, and it's great to see.
Oh, wow. Well, it's very kind of you. We appreciate it. A lot of smart people working pretty hard. So we're grateful that you notice. But let's talk about the book. Tell people what the general thesis is and why you wrote it.
The book looks at this Supreme Court, this supermajority of 6 very conservative justices, by and large working in lockstep, who have attained great power and are moving the court sharply to the right with a big impact on the country. It looks at the first full term of that supermajority, and the 3 big decisions at the end of last June. The Dobbs case, of course, which overturned Roe v. Wade and put at risk all the other privacy rights in the Constitution, as well as undoing the right to reproductive freedom that women had taken for granted in this country for a half century. The Bruen case the day before, which was by far the most sweeping and radical Second Amendment ruling in the country's history, and a case called West Virginia versus EPA, which began what is continuing, which is an assault on government's ability to protect the environment, in that case, climate change and public safety regulation, using the Constitution by these justices. They crammed decades of reactionary social change into those 3 days. And they seem intent, by and large, on moving forward on other goals. And one of the things I look at is, how did we get to this point? How did the Supreme Court amass this much power? There's actually, as it turns out, a history of overreach and backlash, a few other times in our country's history, that's helped shape the country. I want to get people thinking about this, and I want to get people organizing and pushing back, because part of the lesson is that we can push back against a Supreme Court like this.
Yeah, that's very important. I want to talk about those 3 cases, and I want to talk about, of course, this term and upcoming cases in the future. But let's start with the past. You start with the past in your book, so let's try to preserve a little bit of chronological integrity here. You start out talking about the Constitutional Convention and how really relatively short shrift was given to the judicial branch at the convention. Tell people about that, how that played out.
Well, it was the part of the Constitution dealing with the courts, and the Supreme Court is 1/10 the length of what's given to the Congress and the presidency, these more democratically accountable branches that they thought would be the dominant branches in our government. And there's reason to think a lot of them did expect there to be some kind of judicial review, especially by federal courts over state laws. But I don't think that even back then, there was the expectation that you would have the Supreme Court evolve into this super legislature that not is only is part of checks and balances, but in a lot of ways is over the other 2 branches. That took place over time. But slowly. I mean, most of the time in the country's history, the Supreme Court kind of hugs the middle. For better or worse, it reflects the political consensus of the era, and at least the elite political consensus.
Right.
It's really fairly rare for it to be so activist, so ideological or partisan, that it provokes a backlash. It's happened a few times, but most of the country's history, the court didn't play that much of a role.
Yeah. I guess a conservative might say, hearing you say that, I guess a conservative might say, well, what about the Warren Court in the 60s? And like, what would your response to that be?
Well, I talk about the Warren Court in the book,
Yeah.
and
Yeah.
that while I revere the court's rulings, and so many of them are outcomes that I think highly of, I think that the pace of the rulings was so much that it did create a backlash that we're living in to this day.
Yeah.
It was the only time, interestingly, in the whole history of the country where the Supreme Court was kind of ahead of the country in terms of
Yeah.
advancing rights and equality. The other, the first time the court overdid it, if you want to say that, was in 1857, when the Dred Scott ruling said that slavery could not be barred by Congress from the territories. In fact, it was national, and not only that, but Black people were so inferior that they could not be citizens. The backlash to that was so explosive, it led to Abraham Lincoln being elected president of the United States.
Right.
And that was, by the way, the first big case to leak to the incoming president-elect, who was trying to get them to make a ruling like that. And when he had his inaugural address, James Buchanan said, well, we know the Supreme Court's going to have this big ruling on slavery. None of us know what it's going to say. Let's all just agree that whatever it says, we'll go along with it, right? And pretty much everybody, the newspapers the next day said, well, we know what that means.
Yeah.
It was seen as a political takeover.
Yeah.
And Lincoln saw it as a conspiracy, and it created the backlash that helped create the Civil War, the end of slavery, and the Reconstruction Amendments. The second time, again, the court was reactionary. It was the early part of the 20th century, the period of great social change and inequality, when the justices of that moment thought their role was to stop government from regulating, from protecting women and workers and public safety, and through rulings striking down all these new laws that were being passed. That's known as the Lochner era, after a particularly notorious case. And I hadn't realized just how big a political issue that became. Teddy Roosevelt in 1912, backed by so many of the writers from the New Republic, when he ran as the progressive candidate for president in this epic race where he was challenging his successor, William Howard Taft, and Woodrow Wilson was the Democrat, and Eugene Debs was the fourth candidate.
Yeah.
Teddy Roosevelt's big issue was taking on the Supreme Court, actually taking on the Lochner case and cases like that. Right. This was a major mobilizing political issue, all the way up to, of course, his cousin Franklin. You don't want to mess with the Roosevelt boys if you're a Supreme Court justice, who took on the court, proposed court expansion, court packing, failed, but the court backed down. And as I say, the only time when the court sort of departed in some ways from the political consensus of the country in a more pro-rights, more pro-equality way was the 1960s and 1970s, and opened itself up to the criticism that these were political rulings being made by unelected judges, all very ironic given what's happening right now.
Yeah. Now, talk quickly before we get to these three cases that are the core of the book. Talk about the more recent history, like since Reagan and the court's shift from liberal to conservative. Berger was a transitional chief justice, I would say. Then you get to Rehnquist under Reagan, and I think Thomas's replacement of Thurgood Marshall was obviously very, very pivotal. But it took a long time, even though there was a conservative 5-4 majority in name in the Reagan era, it kind of took a long time for the court to change its ideological stripes in a big way. Would you agree or disagree with that assessment?
Yes, that's right. And even in the John Roberts era, when more ideological conservatives took over, but it was a 5-4 majority, Roberts was pushing the court to the right, but carefully, with an eye toward public support, public legitimacy. I should note, with one exception, on one set of issues, Roberts was just as activist as the most activist judges, and that was on the law of democracy. Citizens United striking down a century of campaign finance laws, Shelby County in 2013 gutting the Voting Rights Act, and other cases like that. Roberts was really out there on the law of democracy, but as a general matter, the court was conservative, but was cautious and careful in how it was doing it. This is where the 6 votes of the supermajority make a big difference.
Yeah.
There's actually a tape of Abe Fortas talking to Lyndon Johnson, the great vote counter, about what difference it makes to have 6 votes in the Supreme Court versus 5 votes. Because it means you don't have a swing vote who everyone can appeal to.
Yeah.
And right now there is, even just John Roberts is only 1 vote. He holds the gavel, but Thomas holds the power by and large. And you see that on cases over and over again last year and presumably this year as well, although the recent Voting Rights Act case was a very welcome surprise deviation from that. This role for the Supreme Court, it's quite interesting. This didn't start with Mitch McConnell, didn't even start with Leonard Leo and the Federalist Society, although we now know that a faction of a faction has captured this court, part of a very well-oiled and well-funded, as it turns out, political machine. I always used to look at the Federalist Society and say, well, they're very effective, but they don't actually seem to have that much money. Well, it turns out somebody had secretly given Leonard Leo $1.6 billion a couple of years ago to use, and he uses it very aggressively. But what's striking too is that this is not such a new thing. The Democrats have won the popular vote in 7 of the last 8 presidential elections. That's the longest winning streak in American history in the popular vote. But Republican presidents have appointed 6 of the 9 justices. The last time, Democrats and Republicans have kind of split control of the White House pretty evenly for the last half century. The last time a Democratic president had appointed a majority of the Supreme Court was 1970. And here's a trivia question that not many people will get. The last time a Democratic president appointed a Chief Justice of the United States was 1946.
Oh my God.
So a lot of that is happenstance. It's the nature of having these lifetime appointments without regular appointments. But it's a structurally, functionally conservative institution that's now become a radically conservative institution.
My favorite piece of Supreme Court trivia like that is Thurgood Marshall. He retired while George H.W. Bush was president. And there was some debate then about whether he should have stayed. He ended up dying the first week of Bill Clinton's presidency. So in other words, if he had stayed until he passed away, no Clarence Thomas, and Bill Clinton would have filled that position. Anyway.
And conversely, and as I talk about in the book, Ruth Bader Ginsburg, a lot of people thought she should retire earlier. She didn't. She said, oh, you'll never get somebody approved by Congress as good as me, basically. That's what she said. And then, of course, after battling cancer for many years, she died just a few weeks before the 2020 election. And Amy Coney Barrett was rushed through. That was a breach of norms. What happened with Merrick Garland in 2016 was unprecedented. For the Senate to simply refuse to consider the Democratic president's nomination. It's one of the reasons a lot of Democrats consider that to be a stolen seat. But it's only one of the seats in the supermajority.
Yeah, but somehow all of these coincidences have worked in the other team's direction.
It's
I don't know how that is.
I want those dice.
Yeah, seriously. Let's talk about the EPA case now. You described it briefly earlier, but tell people what the long game is here for the right in bringing those kinds of cases.
Yeah, I'm really glad to, because as you know, the Dobbs case on abortion, or even the Bruen case on the Second Amendment and guns, are better known. But the West Virginia versus EPA case, which was the last of the 3 big cases that term, it marks the beginning, a big beginning of a long-term assault on the regulatory state. In 1937, when FDR tried to expand the court and actually suffered a big grievous loss and broke up his own political coalition, but the court did back down. was called the Switch in Time that saved nine. And
Mhm.
they said, basically, we're not going to step in the way anymore of regulation of the economy. That's if it's reasonable, it's okay. That's how we built a modern country,
Mhm.
without these ideologues in robes trying to impose their small government or free market views. Now, there was a handful of people, libertarians, business interests, who thought that was a great tragedy. They called it the Constitution in exile. And
Mhm.
they looked over and over again for ways to use the Constitution to persuade these judges to use the Constitution to curb the power of government to act to protect the environment, workers, the public. It didn't work until quite recently. In this West Virginia versus EPA case, what the court said is that even if Congress has passed, it was about a climate change rule, kind
Yeah.
of a tangled case. The rule wasn't going into effect. It's the case, the rule itself is not that important in this context. What they said was, and John Roberts wrote the opinion, they said, even if Congress has passed a law, the text of which gives the Environmental Protection Agency the authority to act on climate change in this instance. Too bad. If it's a, quote, major question, then the agency cannot act.
Mhm.
That was the first use of the phrase major questions doctrine, as Elena Kagan pointed out, in
Mhm.
any ruling. It basically says that if something is important enough to require urgent action, that's when the agency can't act. And the decision maker, realistically, given that Congress has not passed a major environmental regulatory law in decades, it means the decision makers are the judges.
Yeah.
Whatever some Federalist Society judge decides is not to their liking, they can declare a major question without a lot of specificity of what is major.
Yeah.
And we see in a case they took for the next term, the next big wrecking ball coming at regulation, they are clearly going to overturn something called the Chevron doctrine, which gives deference to the experts in the agencies who are interpreting congressional laws that are ambiguous. Again, judges stepped out and let the system work
Yeah.
rather than imposing their own right-wing views. And they took a case on Chevron. And one of the kind of backstories here that's I find pretty interesting. Um, Neil Gorsuch, who's the most ardent, intellectually ambitious person on the court in terms of trying to curb the power of the regulatory state. The Chevron case originally was called NRDC versus Gorsuch.
Mm.
It was from the time when his mother,
His mother. Yeah.
Jane Gorsuch, who was the second highest ranking woman in the Reagan administration, was the head of the EPA, very flamboyant, controversial, charismatic. The Rocky Mountain News admiringly said she could kill a grizzly bear by kicking it with her bare feet. But she cut the agency dramatically. She brought in all the polluters to run the different parts of the agency. There was a lot of scandals, and she was eventually pushed out
Right.
in the scandal over the Superfund toxic waste program. And in her memoir, she talks about her teenage son Neil being despondent over this, and that the liberals had done this to his mother, and said, "Mom, you
Yeah.
taught me not to be a quitter. Why are you being a quitter?" So this is a very particular inside the Beltway origin story
Yeah.
that
I'll say.
the liberals drove his mother out of the EPA, and he's basically waging the same crusade. He's much
Yeah.
more buttoned down. He's not kicking any grizzly bears, but he's trying to find a way to use the Constitution to stop government from running a modern country.
Yeah. And give people a quick sense of where this may go. Like once they eliminate the Chevron deference, what kind of things become possible suddenly?
Well, you basically it would greatly hinder the combination of these two cases and whatever other things they're cooking up down at the Heritage Foundation and Federalist Society as we speak. Regulators would have a much harder time engaging in regulation. The court says, "Oh, we're just letting Congress do it," but as we all know, Congress is paralyzed and deeply enthralled to lobbyists and business interests and campaign money, partly because of rulings by the Supreme Court.
Yeah.
Um, one of the consequences of Citizens United, for example, is that before 2010, that was the year of Citizens United, both parties had climate change bills. Now, the Republican Party in the United States is the only major political party in any major country that denies the existence of climate change.
Right.
And that is in part because of the flood of fossil fuel money into Republican primaries through supposedly independent expenditures. These
Yes.
politicians are worried about getting primaried by people backed by the Club for Growth and others from the fossil fuel industry. And so I think that if this happens unabated, you will see growing limits on what can be done to protect workers, the environment, public safety, product safety, and all these other things. Now, there are things Congress can do to push back. A lot of times, these are interpretations of statutes, and Congress can pass a law restoring the statute. The Voting Rights Act cases, for example, Congress should and could pass a law restoring the full strength of the Voting Rights Act. It just hasn't done it because of the filibuster. It's also the case, if you look at all hope is not lost on climate change, the Inflation Reduction Act, was the most significant climate bill ever in a lot of ways.
Yeah.
But that did it by spending, not regulating.
Yeah.
It's the quirk of the court and the quirk of the congressional rules that you can do things if you're willing to spend hundreds of billions of dollars on them, but not regulate. And so the country gets distorted by this in the end.
What are the other cases? We're going to see some more decisions soon, this being June. What are the ones that you're most concerned about?
Well, if you think about the first year of the supermajority, the big cases were on abortion and guns and the interests of the fossil fuel industry. And that sounds like a caucus at the RNC, right?
Yeah.
This term, the big cases are around race and democracy. And we still have not heard from the court on affirmative action. We expect the court, based on what they've all said, to strike down affirmative action in higher education, to bar the use of race as even a factor in admissions. We continue to be very worried about the Moore versus Harper case, the independent state legislature theory case, which is a truly crackpot idea that somehow the Constitution gave state legislatures power to set the rules for federal elections with no checks and balances from state courts or constitutions or governors or voters, and that nobody noticed it until now. It sounds ridiculous. Right. It's made up. But 4 justices at least thought it was a good enough idea to take the case. It's a very real possibility they may declare it moot because the state court in North Carolina that had previously blocked a Republican gerrymander, they changed their personnel, and so now they've blessed the same gerrymander. And then the other case that was a big case this term, which was a real surprise and a very positive surprise, was on the Voting Rights Act. The Supreme Court has been taking a wrecking ball to the Voting Rights Act for a decade. This has been a long-term, career-long crusade of John Roberts. I'll confess, I from everything I saw, I thought they were going to take another swipe at it in the case involving Alabama that became known as Allen v. Milligan. About redistricting in Alabama. But as you know, instead, they upheld the existing rules. I mean, in a way, that should be not that big a deal, but it was a big deal because it was the first time that they didn't push to undo the Voting Rights Act. It will enable Black voters and other voters of color to try to stop gerrymanders in a lot of states that have robbed them of representation. Will have an impact even on the 2024 election. So it was a very positive surprise, although I do want to again note that there was some good, strong language in there, but it was basically keeping the law as it was. Yeah.
What do you think explains Roberts and Brett Kavanaugh voting with the 3 liberals on that one?
There's a number of possible explanations. Roberts does seem to have genuine instincts to be an institutionalist. He has kept one eye on public approval and public credibility, and you saw it in the Affordable Care Act case too. What was surprising here is this was his personal, hobby, going after the Voting Rights Act, and precedent matters and judicial restraint matters. So it doesn't totally
Sometimes.
make sense.
Yeah.
But what I would also say is that even this court, at least when it comes to Roberts, they have to be aware that public credibility has collapsed. Public approval is the lowest it
Yeah.
has been ever in polls. There's been a fierce political backlash already begun against the court and its rulings in the Dobbs case, especially in the midterm elections and in the Wisconsin election and in these other things. And we've seen the public mobilizing. The Democrats again had the most successful midterm election of any party in control of the White House in decades,
Yeah.
significantly in response to the Supreme Court and also fears over democracy. The Wisconsin Supreme Court election went from an evenly divided electorate to an 11-point swing for the more liberal candidate. And so, the justices are well aware of the world in which they live. I would say, though, that I think the ruling on affirmative action is going to be pretty dramatic, could be wrong, pretty dramatic, and rip up a lot of settled social expectations.
Yeah. You
It's
mean in
also
the other direction, in the negative direction?
in the negative direction, although, interestingly, as you know, the polling there suggests that a lot of people out in the country of all different backgrounds are uncomfortable with the current system of affirmative action.
Yeah.
So it won't necessarily be as unpopular a decision in that way as Dobbs.
Right.
Say.
Right.
But
right.
but we know in the world it's just gonna like overturn the table of things going on in universities and again, not because the world has changed, not because the law has changed, but because the personnel of the court has changed.
Mm-hmm. Yeah. What are your biggest fears about where this court is headed? I mean, they could have this majority for, I don't know, another 10 years, maybe. What do you worry about?
I mean, this is the most conservative court in decades by many measures since the 1930s. It is the most activist court since the 1960s and 70s. And as you say, they have life tenure and they ain't going anywhere. And we see in the Clarence Thomas scandal, for example, the lack of accountability and the impunity with which they're acting. It just gives a whiff of insulation from what seems to most people to be pretty obvious problems.
Yeah.
In the way he had this right-wing billionaire, subsidizing his lifestyle and didn't disclose it. And again, my fears, first of all, are it's not that Clarence Thomas was a liberal and then someone bought him a jet trip and he turned into a conservative.
Right.
It's that in that what original ProPublica story about Thomas and Harlan Crow, there's a photograph of a painting that is of Thomas and Crow smoking stogies at a luxury resort, and it kind of to me looks like the paintings of the dogs playing poker,
Yeah,
but anyway,
right.
but the third person with them is Leonard Leo, and there is a machine now at all levels of the federal judiciary, and we have not had that in our country before, that a political operation, Tammany Hall style political operation, controls the judicial branch. And and we need a strong Supreme Court, an independent court. But if the public thinks it's just political, that it's not a court, that it's just articulating or advancing kind of right-wing policies, it leads to a crisis. The country's heading in one direction and the court is heading in another. I think one of the things that should happen is some reform of the Supreme Court itself. Nobody's so wise that they should be the judge in their own case, and so that's the reason why the Supreme Court should have a binding code of ethics, just like all the other courts. I also think there should be term limits, an 18-year term limit. Nobody should have that much public power for too long. And if you combine that with regular appointments, nominations by a president every 2 years, say, it really would bring the court more in line with the country. And interestingly, that's something that is quite popular among left and right, more than people realize.
Really?
I was on the member of the Presidential Commission on the Supreme Court that President Biden appointed in
Mhm.
2021. And, these
Yeah.
commissions, they often are substitutes for action. And we
Yeah.
were actually instructed not to do anything, not to reach conclusions, rather, at the beginning in public. But something pretty interesting did happen. There were dozens of public witnesses from left and right. Some were for court expansion, some were against, some were for an ethics code, some were against. Over and over again, they said, "Oh, but I'm for term limits." Of course,
Mhm.
there's actually a wide consensus now. Do I think it'll last if it starts moving? I mean, I'm not going to bet on that. You can definitely do it by a constitutional amendment. I think you can do it also by statute. But that's the
Yeah.
kind of, there needs to be a
Why,
focus on,
why can you do it by statute?
because Congress has the power to say that people can be what are called senior judges or senior justices. And
Mhm.
that's been ruled by the courts before as not ending their life tenure. You basically change their role.
Uh-huh.
They still get paid, in other
Right,
words.
right.
Now,
And
so
this
we think,
exists. This exists like at the circuit level where there
yeah, I
are
mean,
senior judges.
David Souter
Yeah.
retired from the court decades ago, and he's still hearing cases, for example. Um, this exists at the circuit court now. I mean, to make it work, we would have to require them to become senior justices, but I think they have the power to do that. So now,
Mhm.
people point out, well, okay, who would decide if it's constitutional or not?
Yeah, right. I
The
was just
Supreme
going to ask
Court.
that question.
But I have to say, maybe, but if the public wants Congress to pass this, and the Congress, implausible as it may seem, passes term limits, and then the next day the Supreme Court strikes them down, I think you
Yeah,
get a constitutional amendment lickety split. I
yeah.
mean, that's that's the kind of thing that happens. But I also think that what has to happen is um, we need to focus more on state courts and state constitutions. We need to be
Yeah.
much more willing to consider things like constitutional amendments. And above all, we need to fall out of love with the Supreme Court, progressives
Yeah.
and liberals. We
Yeah.
need to embrace judicial restraint
Yeah.
as a value, and try to win in the court of public opinion. And there's this long afterglow of the Warren Court, long after it was a description of any current reality. I
Yeah.
think the public now, especially liberals now, who until a couple of years ago, the polls showed Democrats had a much higher view of the Supreme Court than Republicans, notwithstanding everything going on. I think there's a dose of realism that people have now that gives me some hope.
Well, I've fallen out of love, that's for sure. And I did revere the court when I was young. My dad was a lawyer, and we had the brethren around the house and all that sort of stuff. And I think that's how that mythology was made in millions of American households. Listen, let's wrap up, but before we go, let's change the subject real quickly. I assume you read the Trump indictment.
I
I
looked
don't
at
need you to.
I looked at the pictures.
Okay, yeah, yeah. Well, every picture tells a story. Um,
Who has a
uh,
chandelier in their bathroom? But that's
yeah,
a different issue.
exactly. uh, what are the constitutional questions here in your mind, if there are any? This is unprecedented, but it's unprecedented because his behavior is unprecedented. So, what strike you as the interesting constitutional issues here?
And as you know, Trump, like in 2020, for example, kept insisting the Supreme Court was going to rescue him, and
Yeah,
they never did. I don't think there are a lot of constitutional issues here.
yeah.
I think there are more structural questions about local prosecutors bringing cases.
Hmm.
Um, Again, not legal, but do we really? There's all kinds of reasons why we as a society have not done this before, have not had this happen before. Um, you don't want to have a retaliatory spiral. There's all kinds of reasons to be cautious, but we've never had somebody as flagrantly criminal as this before, as president and as ex-president.
Yeah.
So I don't think there's a constitutional issue, because this federal prosecution in particular is relying on very long-standing laws, and very, by all accounts, very carefully documented violations of those laws. I think that in some interesting ways, some people have noted that it is less worrisome, perhaps, that a former president is being indicted for crimes committed relating to his presidency, I mean, he wouldn't have access to these documents as a former president,
Right.
if he hadn't been president. This is all stuff when he was a private citizen, but that he's the head of the opposition party. And again, as we look at other countries, we don't want to be like Brazil, where, Lula goes to prison and maybe Bolsonaro goes to prison, sort of, where it seems that there may be a weaponization of the judicial system in that way. But again, I don't know that there's a choice when he's as flagrant as he is. And I sure hope that if there are prosecutions to be made, that there are prosecutions around his attempt to overthrow American democracy, whether it's the state prosecution in Fulton County, where he's on tape, saying find 11,000 votes, or something from Jack Smith, from the special prosecutor, relating to the January 6th insurrection. To me, those are the greatest crimes Trump has committed.
Yeah.
So yeah, it's absolutely uncharted territory, but we've never had anybody like this. And so it makes me queasy, but I think what's probably making me queasy is his conduct more than anything else.
Yeah, I see why the documents issue is the cleaner prosecution for Smith, but I'm with you all the way. I mean, the January 6th was his worst crime. And
Well, and there's been, I mean, when the documents story first broke, I was, kind of a little skeptical, in that, like, there's a lot of overclassification of documents, as you know. I always say, if you walk around Northwest Washington, D.C. and go in the basement, a lot of the houses, and kick open some boxes, a lot of documents will fall out.
Yeah.
Having said that, when you read the indictment, at least, it's really not about abuse of classification. It's obstruction of justice.
Yeah.
It's the very most precious national security crown jewels, defense of the country, invasion attack plans waved around for bragging purposes. And as you know, Mar-a-Lago is probably honeycombed with spies.
Yeah.
And the idea that this stuff was stored in the ballroom where anybody could rent it, I mean, it's just, it's funny in some respects, but it's horrifying too. So I think that there are obstacles to the success of the prosecution, not least of which the fact that the judge who was assigned the case is the judge who was so pro-Trump earlier, and swatted down by conservative Court of Appeals judges for that. But I don't think there's anything is a slam dunk, but certainly they made a case of grave misconduct in ways I didn't think I would find. This is not a technical prosecution, as it turns out.
Yeah. No, I agree with you. Well, we shall see. Michael Waldman, the Brennan Center for Law and Justice. And folks, as we watch these Supreme Court decisions be handed down this month, go to Brennan's website and read their reactions. They'll have smart things to say, and you'll learn something there, I promise you. And pick up Michael's book, Supermajority: The Year the Supreme Court Divided America. Michael Waldman, thanks.
Thank you.